Determining whether a will-based or a trust-based plan is best for your situation is an important decision. If you want the absolute simplest plan, and when an attorney says simplest, he or she means least expensive, then you're going to want to go with a will-based plan. There are two big differences between a will-based plan and a trust-based plan. A will only takes effect upon an individual's death, whereas a trust takes effect when executed and allows you to control your assets both while you are alive and also upon your death. Additionally, while a will may be less expensive to set up, they can be more expensive to administer upon your death. Why? Because a will goes through probate. Probate is the process of proving in court the facts set forth in the will. As you can imagine, anything involving a court is going to be expensive and time-consuming. While costs vary greatly, you will see many estimates of costs ranging from 3 to 7% of the total estate value. Thus, on a $500,000 estate, probate costs could range between $15,000 and $35,000. Trusts do not go through probate and thus aren't subject to probate fees or the court's extended timeline. Ultimately, whether to do a will-based or a trust-based plan is an individual decision. However, there are a number of factors that will influence whether you go with a will or a trust. In general, a will is the best choice for you if you meet the four following criteria. First, your estate is less than $500,000. As the size of your estate grows, you'll likely need a trust. Second, mixed families, those with stepmoms, stepbrothers, and stepsisters, are prevalent but require more advanced planning. Thus, a will is more prevalent for families either with no children or children from only your current spouse. Third, if you own a substantial business interest, a will might not fit. And finally, if you have children that need specialized planning, such as a child with disabilities, a will won't be appropriate. On the other hand, a trust is going to be appropriate as your estate grows. In fact, for many younger couples, they will start with a will and then, as their estate grows, move to a trust-based plan. So a trust is most likely the best choice if your estate is over $500,000. Additionally, if you own real estate outside of Wisconsin, you'll want to go with a trust because you'll have to open up a second probate. If you think one probate is expensive, a second is even more so. If your business is a substantial piece of your estate, you'll want a trust to maintain privacy. Finally, if your children are receiving any state or federal benefits, the specialized provisions of a trust will be required. So there you have it. At this point, you may be able to decide for yourself whether a will-based or a trust-based plan is best for you. If that's the case, simply click on our secure questionnaire, complete, and forward it to our attention. If you're not sure, feel free at any time to contact our office and set up a no-obligation consultation with one of our attorneys. Either way, now is the time to act.